Hi, welcome back to another episode of Law Scholars. We are still talking about criminal procedure, and we are still talking about remedies for what happens if the police engage in misconduct. Well, we thus far have talked about the exclusionary rule, which is the exclusion of evidence at trial against a defendant for the police misconduct. Today we are talking about another remedy, both civil tort liability and then criminal liability for officer misconduct. Those are going to be the two things that we cover. I do want to say that some of the material at the end of this episode is going to be relatively sensitive. And so a quick disclaimer before I get into that material is that I won't be sharing any opinions about whether or not I think that the officer in question should have been convicted, or whether or not the jury got it right or wrong. I don't want to have any discussion about that, and so ultimately it's just going to be a matter of the rule, and just kind of is there to illustrate why it is so difficult to convict officers of a crime for police misconduct. Okay, let's talk about civil tort liability. Well, as we mentioned, talking about the exclusionary rule, before the exclusionary rule was a thing, the primary method of holding officers accountable for illegal searches was going to be civil tort lawsuits. So they're focused primarily on false imprisonment or trespass, but there could also be civil right causes of actions for state or federal. On the federal aspects, that's going to be 42 U.S.C. 1983, Section 1983. Those are going to be your civil rights actions. The challenges presented in these lawsuits, though, is that the police departments have sovereign immunity, and so police departments have sovereign immunity and officers have qualified immunity as long as they acted in good faith. So that's going to be the issue here. It's kind of hard to find an officer liable because of this qualified immunity. So consider Bivens versus 6 unknown federal narcotics agents. In that case, the petitioners were entitled to recover monetary damages for violations of the Fourth Amendment. That's going to be your civil tort liability. Okay, we have three cases related to civil tort liability: Harlow versus Fitzgerald, Anderson versus Creighton, and Hope versus Pelzer. Let's start with Harlow versus Fitzgerald. This is going to give us the definition of qualified immunity. Well, the old rule for qualified immunity is that if the official knew or reasonably should have known that the action he took within a sphere of official responsibility would violate the constitutional rights of the plaintiff, or if he took the action with the malicious intention to cause a deprivation of constitutional rights or other injury, well, then there is no qualified immunity. This rule is a little faulty, at least in Harlow versus Fitzgerald, because it talks about the subjective malicious intentions of the officer, and so you're kind of looking into the subjective basis of the officer's reasoning, which can be kind of hard to prove at times. And so, especially if the officer is performing discretionary functions, such as conducting an arrest. So what is our new test? Well, Harlow versus Fitzgerald says that officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So that gets us into this reasonable basis test to remove that subjective element and discuss the reasonable basis. So at summary judgment, the judge is supposed to examine whether or not the law was clearly established. For times when the law is clearly established, there is no immunity because the officer is expected to know the law. So the question needs to be answered before discovery actually begins on whether or not qualified immunity is going to apply, because it is a statutory interpretation there. So to summarize, the purposes of qualified immunity are to ensure that officials are not harassed by endless lawsuits, to make sure that they do not need to defend against improper lawsuits or frivolous lawsuits, and then it encourages only the valid claims to come to proceed past summary judgment. But to meet the needs of individuals, the courts will determine whether officers are conducting discretionary functions. And if they are, well, then you're going to use that reasonable person analysis. For certain individuals, though, there is absolute, not just qualified, because qualified means you can overcome it, but there is absolute immunity for certain individuals. These are going to include judges, legislatures, prosecutors, and the President of the United States, as long as they are acting within official acts. The interesting thing about Harlow versus Fitzgerald, you might recognize the name Fitzgerald. There is another famous case. It was called Nixon versus Fitzgerald. And that was a case about qualified immunity, or rather the absolute immunity of the President of the United States. This was related to Watergate and the events that happened around that time. And Harlow versus Fitzgerald was related to documents that had been gathered in violation of not necessarily officer misconduct, well, police officer misconduct, but the misconduct of officials within the executive branch of the United States. But this still applies to officers because officers have qualified immunity, and so the test can be read to apply to officers as well. Let's talk about Anderson versus Creighton. Just a quote from Anderson versus Creighton. It says, "The contours of the clearly established right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. As not to say that an official action is protected by qualified immunity unless the very action in question has previously been held unlawful, but it is to say that in light of pre-existing law, the unlawfulness must be apparent." In other words, using the objective analysis must be done on a case-by-case basis. For instance, the court would ask, would a reasonable officer believe that there is probable cause and an exigent circumstance to enter a house without a warrant? Understanding the need to encourage continued officer participation, meaning you want officers to actually be officers and engage in the law, and to do so without fear of the law, meaning fear of liability. A reading of the law in broad terms is not a way to manage the issue, the problem. If that was the case, any pleading that was argued in violation of the law would satisfy a showing that the objective standard had been violated. Instead, the court needs to look into the reasonable belief of the officers based on the information that they were provided with at the time of their actions. This is not a reasonable, unreasonable standard, meaning reasonable to do the search, but it was unreasonable actions, and because the court is considering two different things and have applied this standard in the past. The dissent in this case, though, in Anderson versus Creighton, argued that this is a double standard. Applying the reasonable, unreasonable standard gives the officer two opportunities at qualified immunity. And so the officer's interest in that was protected once, while the subject's interest is the officer's interest is protected twice, while the subject's interest is protected only once. And this is an issue with the dissent. The standard of probable cause requirement is well settled and clearly established, and any violation of that standard may overcome the qualified immunity. What happened in Anderson versus Creighton? Well, the FBI had showed up to the home of a family believing that they were harboring a fugitive. They demanded to enter the home. They did enter the home, abused the family, did not discover the fugitive. The fugitive was not there. Caused, I believe, a hospitalization of the father of the family. And so now it's a matter of whether or not the officers here are civilly liable for the issue, and whether or not they could overcome the qualified immunity. And so that's what the majority was talking about. You don't want it. You want the officers to fight crime without the fear of the law coming against them, and a reading of probable cause. Because so what they're saying is the officers, as they came in, were saying, we have probable cause. We need to get this person now. We have an exigent circumstance. We don't have a warrant, but we do have probable cause. And now it's a matter of whether or not a reasonable officer would have assumed probable cause based off of this, based off of the information that was present to the officer at the time of the entry into the home. And the court said, yes, a reasonable officer could see that there's probable cause. The dissent, though, is arguing that the probable cause analysis already takes into account reasonableness, and for that reason, we already have a good definition of probable cause, and you can't use that as a way to overcome the qualified immunity standard. Okay, one more case. We got Hope. Well, as far as the civil tort liability goes, we got Hope versus Pelser. So in 1995, Alabama was the only state that utilized chaining prisoners together in work gangs. In this case, what happened is, as the prisoners were on a bus to go to work in one of these chain gangs, Hope, the plaintiff in this case actually, took a nap on the bus and was quite slow to respond when the officers woke him up to get off the bus to go to work. Words were exchanged, wrestle match ensued, and Hope ended up being subdued by the officers and taken back to the prison. And that day, Hope was chained to a pole and was denied water and bathroom breaks. That happened in 1995. The laws at issue here is that in 1974, this practice was prohibited as a violation of the Eighth Amendment, but in 1987, prohibiting water tubes to prisoners was allowed. So, does this mistreatment of Hope, can Hope sue for this, and will the officers get out of it based off of qualified immunity? According to the Court of Appeals, a reasonable officer could have seen this as clearly unlawful due to the 1974 case. That was the one that said that this kind of treatment is a violation of the Eighth Amendment. But this 1974 case seems to have been, this Hope versus Pelser case seems to have been the exception. In other words, this was unlawful treatment of Hope, which was able to overcome qualified immunity. But this case seems to be the exception, where most cases end up with officer actions to result in qualified immunity. Our big takeaway from these cases is that qualified immunity is actually a really tough standard to overcome for plaintiffs who are seeking to say that qualified immunity should not apply. Okay, let's talk about criminal liability. And as I mentioned, this is a sensitive subject, and I won't be getting into any opinions regarding the trial or anything like that. Just simply what happened here. Okay, State versus Chauvin. If you guys are familiar, which you'd have to be living under a rock to not be familiar, George Floyd was an individual who was arrested, and then he had the officers ended up pulling him out of a vehicle, kneeling on his neck, and he ended up suffocating and dying based off of these things. And so now the question is, the standard qualified immunity rule, does that apply to criminal cases? The answer is yes. Qualified immunity applies to criminal cases, but is Chauvin going to be criminally liable for homicide in this case? Well, we in class we looked at several experts in the Chauvin trial. First main expert for the defendant, meaning Chauvin, was Berry and Broad, which said that Mr. Broad, he had a three-part analysis about the use of force in the Chauvin case. The first prong is whether or not there was a justification for the detention. Second prong was the level of resistance utilized by the subject. And the third prong is whether the officer's reaction was proportional to the resistance exhibited by the subject. This expert applied that analysis to the detention of George Floyd, and this expert determined that the use of force was justified, which resulted in an accidental death of George Floyd. So now the defense here, they set up their standard, they set up their barrier, their wall of qualified immunity. And this is a very tough wall to overcome. So now we have three different experts from the prosecution in an attempt to overcome that wall. There's Seth Stoutson, who uses the same analysis, the proportionality analysis that was issued by Berry Broad, and they said that this was an unreasonable use of force and that no reasonable officer would have used that force. This expert also stated that the failure to provide medical aid was also unreasonable. Then you have Jody Steger, which was another expert for the prosecution. Mr. Steger was familiar with the proportionality analysis and said that no force should have been used once the subject had been restrained. And then most importantly, the prosecution had Minneapolis police chief testify that Chauvin had violated the department's policy regarding the level of force that was used to detain Floyd. In other words, you've got one expert here from the defendant, and then you need to have these three experts here illustrating how to put in to kind of combat this defendant's expert. So what's our takeaway from this case? Well, the point of illustrating this case is that the testimony here provided by the defendant puts a bit of reasonable doubt into the minds of the jury, and that's a pretty difficult standard to overcome. So how do you overcome the defendant's attempt to put a bit of reasonable doubt into the jury's minds? Well, once you have that defendant testimony, it's pretty hard, and it takes a lot of work for the prosecution to do so. And to do that, you need to also have outside experts, and you need to have inside experts, and then you need to have other officers, and primarily the chief of police, who is going to say that the officer was in violation of the department policies. And that's what happened in this case. Chauvin was found guilty of, I believe it was murder. It might have been an upper level of homicide that is less than murder. I can't remember 100% what exactly the result was. But the whole point of bringing this case up is not to say whether or not Chauvin was guilty or not, or how George Floyd died, or the means of his death, whether it was the force of the officer, whether or not it was the drugs in his system. None of that is supposed to be the focus of this. I just wanted to show that once the defendant puts up an expert, it's pretty hard to overcome that expert. And the prosecution here was successful in overcoming this by presenting both outside experts, inside experts, and then the chief of police primarily, and to say that Chauvin had been in violation of the department policies. All right, that's everything as far as this material goes. We talked about civil tort liability for officer misconduct, and then we also talked about criminal liability for officer misconduct. And primarily that is the standard of qualified immunity and how to overcome qualified immunity, or the application of qualified immunity primarily for the officers, and why that is a very tough standard to to combat. But that's everything. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.